Good evening, students. Today we are going to discuss the statements that Nishikant Dubey made regarding the Supreme Court, specifically in relation to how he spoke that the judiciary was initiating, the Chief Justice was initiating the civil war. And what was the response of the Supreme Court regarding the same, and specifically how they elaborated on what is the nature of criminal contempt and whether any action would be taken against Nishikant Dubey. I'll share the screen and we'll discuss further. So, if you see this particular order which was passed, it was a petition in relation to wanting suo motu criminal contempt proceedings against respondent number 4, Nishikant Dubey. Now, this was in relation to the directions also, or in context of the directions which were given by the Supreme Court of India and the Chief Justice of India, which told the Ministry of Home Affairs of the Union of India to lodge FIRs under the BNS, as well as to hold caution against hate speeches of political parties and their leaders in relation to the Amendment Act of 2025, right? So in context of that, there was a lot of skirmishes taking place, and furthermore, we will look into the statements made by Nishikant Dubey. But before that, the Supreme Court in this order elaborated on what are the freedoms that each individual enjoys through the Constitution, as well as the fact that where does criminal contempt come into picture. So the court started off by saying that in context of having the right to criticize objectively, that is a fundamental right of free speech which is protected under clause A of article 19.1. Now, the power of criminal contempt exists. However, it has to be borne in mind that it can be used only when you make statements which scandalize or lower the authority of a court, interfere with the due course of judicial proceedings, or they obstruct the administration of justice by large. So, in generally, we can say that these paradigms are what would be considered to be acts which are called or considered criminal contempt, right? But the court makes a statement. It says that the exercising of the power of contempt is discretionary. It is the discretion of the court to decide whether or not they want to uh, take action of criminal contempt against the individual. Now, examining whatever was mentioned by Nishikant Dubey, the court felt that it was coming under the ambit of criminal contempt. It did scandalize and lower the authority of the Supreme Court of India, and it did have a tendency to interfere and obstruct the administration of justice. And therefore, the statements made reflected the clear intent to impute motives to the bench itself by naming the Chief Justice of India. So, his statement was that he is responsible for all civil wars happening in India, and in order to incite religious wars in this country, it is only and only the Supreme Court that is responsible. So basically, alleging that the Supreme Court was causing a situation of unrest and religious discord in the country. And the court clearly states that they feel that this was an intentional act and would come under the paradigm of criminal contempt, right? But furthermore, they reiterate that fact that it was irresponsible of Nishikant Dubey to make these statements and was basically done to attract attention, and they were the casting of aspersions on the Supreme Court of India and the judges of the Supreme Court through these statements, which was considered disappointing by the Supreme Court. But the Supreme Court spoke about the judiciary's stature, structure also. It said that the Supreme Court and the judiciary by large is not as fragile as flowers to wither and wilt under ludicrous statements. They do not believe that confidence and credibility of the courts in the eyes of public can be shaken by the absurd statements. So, referring to what was said by Nishikant Dubey, the court felt that the public will never make an assumption on the credibility of the court on the basis of these type of statements, though it can be said without a shadow of doubt that there is a desire and deliberate attempt to do so. So, reiterating that they felt that what was stated by Nishikant Dubey was intentional, but the court said that they were not feeling that the nature of judiciary is also to be vulnerable to criticism, as was referred to in this para, that there can be circumstance where decisions, etc., are open to discourse. And in fact, even in the decision, the court says that there are several situations of discourse discussion in a case, and that is inherently a part of the justice system. But wherever it is done with an idea of downgrading or intentionally obstructing justice, um, through the line of making statements of such nature against the judiciary, they must not be dealt lightly. So, both statements were made by the court saying that criticism is a necessary aspect of justice, also, and of in the case of judiciary, also, they are not immune to criticism, but at the same time, in cases where there is it shows that the statements were made and would come under the ambit of contempt, then action can be and should be taken. But in this incident, the court reiterated that it is a discretionary act, it is a discretionary power with the court whether or not they would like to bring action for criminal contempt against the individual or initiate contempt against the individual. And they reiterated that it is not necessary for every statement which is of derogation or which is of ludicrous nature that the court may exercise the right to initiate or the power to initiate contempt. Right? I'll quote this part, which states that courts believe in values of free press, free trial, judicial fearlessness, and community confidence. Therefore, the courts need not protect their verdicts and decisions by taking recourse to the power of contempt. So they feel that in because there is the aspect of free press, fair trial, judicial fearlessness, and community confidence, it is not necessary in order to maintain its authenticity that at every occasion the recourse to power of contempt must be taken. Courts and judges have shoulders broad enough and an implicit trust that the people would perceive and recognize when criticism is critique biased, scandalous, and ill intentioned. So the court defined criminal contempt, mentioned that it's discretionary, reiterated that the statements made by Nishikant Dubey did come under the ambit of criminal contempt. However, they stated that they did not want to extend action and that all situations or circumstances where such statements do not require the court to initiate action of contempt. As I said, making the statements that they did, that the judiciary was stronger than that. It further also mentioned the innate requirement of judicial review, which is a part of the judicial, the requirements from judiciary, that judicial review must be an aspect that they look into. It reiterated that the relationship amongst the three wings of the government having their three different roles are distinct, and judicial review is very much a part of what the judiciary has to do, and it still continues to maintain that separation between the three organs, reiterating the fact that whatever the judiciary directs or commits to through the acts of judicial review is in order to protect and with well within its right as an organ of the government, right? While we are not entertaining the present writ petition, so the court didn't take action. They made it clear that spreading of communal hatred and hate speech must be dealt with seriously. It cannot be tolerated, as it causes loss of dignity and self-worth to targeted groups and contributes to disharmony amongst groups. Therefore, reiterating the same that hate speech, as it initially said, should not be tolerated, the Supreme Court did not feel the need to go ahead and take action of contempt against Nishikant Dubey, reiterating the discretionary aspect of criminal contempt, also emphasizing the fact that the act did amount to, did have facets which would have brought it under the ambit of criminal contempt. So I hope, students, I could give you a short overview of what the decision brought in, an outline of what criminal contempt is, and what happened, what actually happened in the Nishikant Dubey case. It has also come to my notice that post this set of statements, he did make more tweets regarding the same. And we see that the decision of the court highlights the understanding of the fact that the statements were intentional, especially the ones which are provided in the order were intentional, and even though they did come under the ambit of criminal contempt, the court did not consider to take action, criminal contempt being discretionary in nature. Any particular topic, students, if you are interested for me to take up, or case laws, kindly let me know in the comments. Thank you so much. Have a great day.